there was an uncertainty about just how much equality under the law the state would permit. And white folks generally wanted no equality for African Americans, and black folks obviously wanted their full citizenship, the rights that they were entitled to under the new Reconstruction Amendments. And generally that fight went on, and there was an uncertainty about what it actually meant until a case went before the U.S. Supreme Court. And that case we now remember as Plessy versus Ferguson.
Welcome back to the channel, everybody. I hope you're doing well. We're going to go ahead and hop right on in to Plessy v. Ferguson. Most of you know of this case, but would probably think of it more as separate but equal. The doctrine that came out of it that wasn't overturned until Brown v. Board of Education in 1954, which is a case that we'll cover later on. Our main man in this case, Homer Plessy, was born in the 19th century. He was something that at the time was called an octoroon in a rather loose way. He was someone that was 7/8 white, 1/8 black. His family was largely French. His parents had come from Haiti after the revolution to escape the violence. As a result of that, he and his parents were all free, living in Louisiana at the time, so that is an important distinction. Now, Plessy ended up, as he grew up in this particular situation, he joined in on the reformist portions of the society, looking for abolition of the slaves and the enfranchisement of not white people. By the age of 30, he had joined something called the Citizens Committee, which was made up of white, black, Creole people in Louisiana, which advocated for the civil rights of non-white individuals. Now, this was all following the Civil War, and up until about 1877, the Union troops had been down in the South enforcing the terms of the new constitutional amendments, the 13th that had freed the slaves, the 14th that provided for things like due process, 15th, all of the Reconstruction era laws and amendments. That's one of the reasons that up through that particular time, you didn't have segregated seating, segregated schooling down in the South. Come 1877, the Union troops get pulled out and things start to change. By 1890, Louisiana was passing a law that mandated that railway carriage companies provide separate but equal accommodations for white and not white customers. As a result, a lot of the railway companies actually opposed this particular law, not off of ideological grounds, but because it cost them money. They now had to have 2 train cars where they used to only have to have 1. And kind of going along with that, the law took a point to actually make it punishable to the railway company should they fail to enforce this particular law when they were providing tickets. And the law also made it incumbent on the railway company itself to ensure that the proper seating was given to the individuals. In short, giving the responsibility to the railway company to determine whether you were white or not for purposes of carrying you. This put Plessy in a very particular position. As I said before, he was 7/8 white, 1/8 black. However, under the laws in the South at the time, that was enough that he qualified as a not white person. An interesting side note, the Germans, when they were coming up with the anti-Jewish laws in the 20s and the 30s, actually looked at the Southern laws on the topic related to not white individuals and found them too strict, and went with something a little more liberal, shall we say, in the approximation for Jewish individuals. That should give you kind of an idea of just how stringent these bloodlines were considered. As a result of this, Plessy actually looked fairly light-skinned. As he said at the time, he could pass for white if he wanted to. As a result, the Citizens Committee asked him whether he would be willing to intentionally violate this law by buying a ticket and then sitting in the white people only section. He agreed. Now, in terms of the history, I've seen a couple of different things from here forward. One line of argument that I hear is that Plessy he bought his ticket, and then intentionally went to the white people section, was told by the train operators, no, you have to go to the not white car, and he refused. Police officers then came and took him away. I've also seen an argument that it was staged by the Citizens Committee themselves, and that they hired a private investigator with arrest abilities so that no matter what, Plessy would find himself being removed from the train in handcuffs to ensure that this particular argument could get before a judge. Which one is accurate? I'm not sure. I'll leave that up to you to go and investigate. Either way, I highly doubt that the result that they received is what Citizens Committee was hoping for when they asked him to go and purchase this ticket. This particular case was argued in 1896 after some shifting in the Supreme Court had happened and a more segregationist tone had taken hold. Plessy made two basic arguments to the Supreme Court in trying to overturn this particular law and his conviction under it. One was that it violated the 13th Amendment, which freed the slaves, and one was a due process argument under the 14th Amendment, applying the federal constitution to the states. The justices were not overly impressed by these arguments and knocked down the 13th Amendment discussion really quite quickly, pointing out that the 13th Amendment barred slavery and involuntary servitude with the exception of prisoners. This particular law in Louisiana had no implication in stripping away the civil liberties of individuals that were not white, according to this judge. It provided no state of bondage. He said that where you have a statute and all it really does is imply a legal distinction between white and not white races, which it ends up having no tendency to destroy that legal equality between those disparate groups, and it most certainly didn't put them in chains. So the 13th Amendment didn't really apply in this instance. And the judge also took a moment to note that Plessy himself really was not pushing this argument that hard. This was not kind of the moneymaker, if you want to think of it in those terms. The judge then took a look at the 14th Amendment argument, and to start off, he took a look at the history of that particular amendment, how it came to be, what it was supposed to apply to, etc., etc. He came to the determination that the sole object of the 14th Amendment was to enforce the absolute equality of the, as he put it, two races before the law. The judge termed this political equality. He said, however, that it was not the purpose of the 14th Amendment to abolish all of the distinctions between groups of people based off of color or race. Or, he even made a point to say, to enforce that they commingle in a way that they disliked, or force them into close proximity in terms that were unsatisfactory to either group. And I'm sure at this point you can see exactly where this judge is going. The basic thrust of Plessy's argument being that by separating us off of something like skin color, you are indicating that not white people are inferior by our nature. And the judge said no. Laws that separate the races don't necessarily imply the inferiority of one race or another. And the ability to make these kinds of laws is also well recognized within the competence of state legislatures. And then the judge had some fun. To support that particular contention, he looked to the various states at the time, including places like Massachusetts, that had racially segregated schooling. He also took a look at the bans in many states on things like interracial marriage, which, if you saw the video on Loving v. Virginia, you know wasn't overturned as unconstitutional until the 1960s. These separations, these bans, had been previously upheld and were state laws passed by the state legislatures. The judge used them as an example to distinguish what he called the political equality, as demanded by the 14th Amendment, and other kinds of equality, which was sort of open for grabs in his estimation. There was also another case that was strikingly similar to Plessy's that came out of Mississippi not too long before this case, and the facts were almost spot on the same. In that particular case, the railway was required to have separate but equal accommodations for white and not white people, and the train only rode in the state of Mississippi, just like Louisiana that only rode in Louisiana. As a result, this judge found that there was no implication of the Commerce Clause and no other constitutional power upon which Congress could impose itself on the state, or that the federal constitution should be touching. The judge in this particular case liked that result and basically hung his hat on it, saying that in this case, because the Louisiana law only applied to conveyances in Louisiana, that they enforced a separation of the races based off of skin color, which is the marker for this case. There is no abridgment of your privileges and immunities found in the federal constitution. There's no deprivation of property, and there's certainly no deprivation of due process under the 14th Amendment for not white people. This is an internal state Louisiana matter, and the federal constitution had no place in it. And then to go ahead and just rub a little bit of extra, salt in that wound, the judge did what he needed to do and looked also at the reasonableness of the law for 14th Amendment purposes. But to do so, he said that reasonableness should be grounded in looking at the customs, usages, and traditions of the people, which in this case is Louisiana. And in this case, I'm sure you can imagine the customs, usages, and traditions of the people did not find that separating individuals based on skin color was an unreasonable thing to do. Plus, he tried one more argument, and that was related to property rights. An interesting one, actually. He made the argument that having the reputation of being a white person in Louisiana at the time was a property right. It was something you actually owned, kind of like an inheritance. The judge didn't particularly like this argument very much, because the implication was, if you have this property right as a white person and it's taken away from you, you've been harmed. The judge said, assuming that reputation in this case is a property right, it has absolutely no deprivation quality for not white people. Were you white and you were told to go to the not white car, denied access to the white conveyance, that would be a violation of your property right. But if you are not white and you go to the white car and you're kicked out, that's not a deprivation of property, because you aren't white and you have no claim to the reputation of being so. It's sort of a damned if you do and damned if you don't type situation. As a result of this full analysis, the court found that so long as conveyances were separate but equal, you could separate people out by skin color or more generally race in the United States. And with that little bit of nonsense, we kick off about 60 years of judicial gloss of separate but equal, which led to the Jim Crow era of the United States, where, as we have learned ever since, while they may have been very much separate, they were very much not equal. So that was Plessy v. Ferguson. Reach out in the comments below and let me know what you think of the decision. In particular, what do you think of the judge's attempt to distinguish political equality from all other kinds of equality? So let me know what you think down below. And until we are together again, I hope everyone is well.